Good morning, everyone. My name is Leona Rollins. I'm the Housing Services Manager for the City of Ventura. I am joined here this morning by Rachel West, who is a Management Analyst within the Housing Services Division. We would like to take this opportunity to thank Councilmember Campos for joining us this morning for our first of four tenant and property owner collaborative workshops. There is a variety of staff here, including our Community Development Director, Rachel Diamond, our Assistant Community Development Director, Maruja Clince, as well as additional staff from our Housing Services and Planning divisions. So we're gonna go ahead and get started. Okay, so this is going to be our agenda for this morning. So what we're going to start with is a review of applicable state and local legislation. We'll talk about current housing rights within the city, current housing rights in other jurisdictions, regulatory framework for housing rights in the city. We'll do an introduction to our station activity topics. We'll have comments and feedback activity, which will take about 45 minutes. And then we'll conclude the presentation with collaborative workshop next steps. So just some background information. So first, in the state of California, we do have the Costa-Hawkins Rental Housing Act, which was enacted in 1995. It limits jurisdiction from establishing rent control on certain residential developments, which includes single-family homes, condominiums, and other residential developments constructed after February 1st, 1995. It allows property owners to establish initial rental rates for new tenants, also known as vacancy decontrol. We also have California Assembly Bill AB 1482, which went into effect on January 1st of 2020, which limits annual rent increases to 5% plus the local consumer price index, with a maximum being no more than 10% for all rental increases. So from August 1st, 2024 through July 31st, 2025, all cities within Ventura County are capped at 8.8% except for the cities of Ojai and Oxnard. It does provide just cause eviction protections to tenants who have lived at the property for more than 1 year. So if you are a tenant living at a property for more than 1 year, you can only be terminated for fault evictions, meaning things such as non-payment of rent, lease violations, or no-fault evictions with relocation assistance for things such as governmental orders, or the owner wanting to terminate your tenancy so that you can move in to allow either themselves or a family member to move into the property. So California Senate Bill 567, which went into effect on April 1st, 2024, it strengthened components of AB 1482 and allows for stronger enforcement. It ensures property owners are following through with the reasons why they're terminating their tenants, and property owner must offer previous tenants the same rental rate if they do not. So what I mean by that is, for example, if an owner indicates that they would like to terminate their tenant in order for their mother to move into the property, then the mother has to move into the property within a 90-day period and remain in that unit for up to a year. If that does not occur, then the landlord does have to allow the tenant to move back in at the same rental rate and lease terms. There is additional enforcement mechanisms against property owners if they demand or accept any type of incentives. And if evicting a tenant for a substantial remodel, the property owner must have proof of plans, permits, and or contracts prior to the eviction. This is similar language that is found in our own city's ordinance for just cause eviction for demolition and substantial remodel, which was approved by City Council on May 23rd, 2022. So recently, California Assembly Bill 12, which is also known as AB 12, went into effect on July 1st, 2024. It relates to security deposits and caps security deposits to only 1 month of rent. Exception for property owners with no more than 2 residential rental properties that collectively include no more than 4 dwelling units, which allows them to still collect up to 2 times of rent. So before this particular ordinance went into effect, landlords did have the right to request up to 2 times the monthly rental rate for unfurnished units and up to 3 times the monthly rental rate for furnished units. So with this particular ordinance, if you are a larger property owner, you are capped at limiting rent increases, security deposits to 1 month of rent. So some local jurisdictions and their particular housing rights. So we have the city of Oxnard and the city of Ojai, who respectively in 2022 and 2023 adopted their own local just cause and rent stabilization ordinances. Both jurisdictions have capped their rental increases at 4% for multifamily units. It limits the ground for evictions for most tenancies and requires relocation assistance for all no-fault evictions. Relocation assistance is required at a minimum of $5,000 or up to 2 months of rent, whichever is greater. And this applies to both the city of Oxnard and the city of Ojai. So for tenant and property owner in the city of Ventura, we currently partner with the Housing Rights Center to enforce local, state, and federal regulations, which include Assembly Bill 1482, Assembly Bill 12, our just cause eviction for demolition and substantial remodel for residential properties. We also have other local, state, and federal housing laws, which typically includes our fair housing law protections, and of course, Senate Bill 567. So if you are a tenant or a property owner in the city of Ventura, you are able to receive free services from the Housing Rights Center, and we do have information about their contact information available in the rear desk. So there are a total of 48 cities, counties, and towns throughout the state of California, and about 445 of these jurisdictions do not have any local form of rent stabilization or tenant protections. And as you can see for the items highlighted in orange, these are all the local jurisdictions within Ventura County that do not have any sort of local form of rent stabilization or tenant protections. However, they are still subject to all of the state regulations, which includes AB 1482, AB 12, as well as SB 567. There are some jurisdictions that have adopted a form known as just cause eviction at the local level, and these are some of the cities, as you can see here on the screen. There are about 8 of them right now, and there include cities like Glendale, Palo Alto, San Rafael, San Diego, as well as the city of Union City. And currently, there are 29 cities in California that have both a local rent stabilization or tenant protections. And of course, we see the city of Ojai and Oxnard in Ventura County. But there's a number of cities throughout the state that also have adopted local rent stabilization and tenant protections. So some of the regulatory framework for housing rights. So essentially, housing rights are measures designed to safeguard the rights and well-being of tenants as well as property owners. Housing rights can vary by jurisdiction, but some common options include things such as anti-harassment, just cause eviction, free or low-cost legal services, rent stabilization, as well as relocation assistance. So we will be having an interactive process this morning. It's called the comments and feedback activity. So we will have 6 stations, which are located in the rear of this room, where each attendee can submit a comment card and provide their feedback on various housing rights topics that we are discussing today. These topics include things as anti-harassment and legal services. We're going to be talking about displacement and evictions, property owner resources and rent registries, rent stabilization, security deposits and right to purchase, and we also have a station for open comments. So anything that wasn't addressed during this presentation, you can have any comments, whether they're positive, negative, pros, cons, whatever you see fit, because we're wanting to engage the community about what they think the city should do and should not do in order to protect tenants and property owners. And now I'm going to hand it off to Ms. West.
Hello, I'm back. Again, Rachel, hello, thank you so much. And like Leona mentioned, all the information stations are back there. We're going to go over each station here. It's a lot of information. Don't feel that you have to memorize it all or anything, because we do also have the giant posters in the back that have pretty much everything that's in the PowerPoint on them as well. We would love your feedback, comments, pretty much anything. Just, submit your cards, please, and thank you so much for participating today. So anti-harassment, what is an anti-harassment ordinance? This type of measure would be laws that protect both tenants and property owners from harassment. And both property owners and tenants can experience harassment in different ways. A lot of times property owners would experience harassment from tenants as a way of the tenants kind of making false claims in the unit when there's not really repairs or issues, withholding rent, or just lease violations in general. And then tenants could experience harassment from property owners in the ways of the landlord not repairing things that have to be repaired. So it's affecting the habitability of the unit. Also, kind of taking away things that were in the lease, and anything that kind of just forces the tenant out of the unit. What is required in the city? As of today, the city does not have an anti-harassment ordinance. But what could the city do? The city could continue to do nothing. They could adopt an ordinance similar to the city of Los Angeles, where it prohibits property owners from harassing tenants by actions such as removing housing services, withholding repairs, or refusing to accept payments of rent. Or they could expand the contract with the Housing Rights Center for additional legal services in conjunction with an anti-harassment ordinance. And there are pros and cons associated. So some pros would be it would provide additional protection for tenants and property owners outside of the protections afforded through federal and state regulations. It would also provide tenants and property owners with an additional mechanism to protect themselves from harassment and other forms of unfair treatment. And some of the cons would be that there are federal and state regulations already providing protection against some forms of harassment like discrimination. And there could be a cost associated with the ordinance if tenants and property owners do not have the financial means to pursue legal action on their own against the other party. Another station out there will be additional legal services assistance. So what are legal services? It's an access to a range of legal help for both tenants and property owners, and can range from providing legal advice and mediation services to providing an attorney for legal representation in lawsuits or eviction hearings. The city does currently partner with the Housing Rights Center under a contract for legal information and mediation services for tenants and landlords. And the legal information is, just super simple. What is the state law? What are the federal laws? What are the fair housing requirements? And that's for both the help of the property owner for them to know their rights as well as for the tenants. And when we're talking about mediation services, we're talking about mediation services for the tenants and landlords to try to come to a compromise to keep it out of the courts, to try to keep the tenant in, or at least try to come to some type of compromise so that both parties are as happy as possible without actually taking legal action. What could the city do? We could eliminate the existing legal services, which provides mediation to tenants and landlords, or we could expand the contract with the Housing Rights Center for additional legal services, and this would be really to provide counsel if it does ever have to get to court, because as of right now, our housing right contract does not have that court piece. So if there is a court case that has to be done, there is no counsel from the Housing Rights Center. That would be the tenant or the property owner both finding their own legal counsel. So pros would provide additional resources to tenants and landlords who are seeking legal advice and a representation in legal matters such as evictions or lease violations. It would provide tenants and property owners with a free or low-cost service to assist them in numerous housing matters such as displacement, eviction, harassment, lease violations, and more. Some of the cons associated with it is that there would be an additional cost to the city to expand these resources through the Housing Rights Center or another legal aid organization, and possibility that legal services may be limited and not to all tenants and landlords, since most of these programs are limited funding and can only assist those who meet certain income thresholds. Additional displacements and evictions ordinance. So what is displacement? Displacement is when an individual loses their housing and is forced to relocate due to property owners selling the property, natural disasters, property improvements that require the tenant to move out, or substandard conditions. So displacements are really when there's no fault of the tenant. It just happens that either the building needs substantial remodels, or improvements, and they can no longer stay there. And displacements are what really kind of lead to homelessness and things like that, because it's usually not predicted and all that, and it's usually a pretty quick turnaround, and then someone has to leave their home and try to find a new unit. What is eviction? Eviction is a legal process through the courts where judgment is made to terminate the rights of an existing tenant due to lack of payment, lease violation, owner occupancy, or substantial remodel/demolition. And there are two types of eviction. There are the no-fault evictions, where, again, it's kind of just the substantial remodel or demolition, no fault of the tenant. But then there are also the where there are issues with the tenant. So it's the lease violations, it's the lack of paying rent and things like that. And so those are evictions are just cause evictions. And what does the city do now? The city has a just cause evictions for demolition and substantial remodel to residential properties, meaning that a property or owner must obtain permits and other supporting documents before serving their tenants with a termination notice to demolish or substantially remodel their property. And the property owner is also required to provide their tenants with relocation assistance, which is equal to 2 months of the tenant's current rent. And again, that's just saying that a property owner has to actually have the permits in hand. It can't be that they're planning on eventually remodeling it in a few years, but they're asking the tenant to vacate. No, the permits have to be in hand and they have to be ready to go. What could the city do? No change to the existing regulations. Do nothing in addition to what we currently have in place. Require relocation assistance for displacement of tenants similar to the other cities. So for example, Ojai and Oxnard, which we talked about earlier, they have the requirement of a minimum of 2 months rent or $5,000 in relocation assistance, whichever one is higher. We in the city do have the 2 months of rent, but we don't have the $5,000 option currently. Or adopt our own local ordinance to reflect SB 567 with stronger just cause evictions to ensure that tenants and property owners are abiding by state regulations. There are pros and cons associated with this one as well. So some pros would be by expanding our ordinance, the city could reduce displacement, evictions, and prevent homelessness in the community. By expanding our ordinance, the city could limit rent increases in the community. And by expanding our ordinance, the city could require additional relocation assistance for displaced tenants. Some of those cons would be by limiting rent increases, property owners may not receive a return on their investment and could cause postponement of property maintenance. Requiring additional relocation assistance may create a financial burden for mom and pop property owners. Property owners, resources, and rental registry, another station that's located in the back. So what are property owner resources? These are online portals, programs, services, advice sites, conferences and events, and local associations. And what is a rental registry? A rental registry is a database of rental projects that include detailed information about both the property owner and the rental property itself. What does the city do now? The city attends various conferences to learn about current legislation and programs that affect real property. We also host different housing forums throughout the year, workshops similar to these. And the city does not currently have a rental registry program. What could the city do? The city could do nothing. Implement a rental registry to assist with compliance of both tenant and property owner with applicable legislation. And some of these pros would include streamlined compliance for property owners, improved housing for residents, improved accountability, and increased transparency. And some of these cons would include the privacy concerns, data safety and protection, cost for the registry, maintenance and oversight, and then inability to raise rent for unforeseen circumstances such as structural improvements. The other station would be the rent stabilization ordinance station. So what is rent stabilization? Rent stabilization is a policy that limits the amount that rent can be increased each year. The goal is to increase housing affordability and stability by protecting tenants from excessive rent increases, which helps to reduce the risk of homelessness and displacement. And rent stabilization really is about stabilizing the rental market. And so what that means is they're usually lower, a fractional of the larger increases, so that would happen yearly. So not only do tenants kind of have that small increase yearly, but then property owners also get a little bit back sooner rather than, I know a lot of property owners typically tend to wait a couple years and then they'll do like a larger increase. So this helps both the property owners get a consistent amount each year as well as not doing a giant increase at the end of like 5 years for a tenant, which could be hard for them to manage. What does the city do now? The city does not currently have an ordinance or any policy regarding rent stabilization. What could the city do? Do nothing other than following the applicable state laws, provide legal guidance to tenants and landlords on allowable rent increases, and the city could create an ordinance similar to other jurisdictions that limit rent increases on eligible properties. These pros would include affordable housing, rent increases are more manageable for the tenants, tenant stability to help stay in homes longer, as well as tenant stability for the landlords that they don't have to go and continuously try to find someone new to rent out the unit. Community continuity and can help maintain socioeconomic diversity, and it protects vulnerable tenants from large rent increases. The cons is it does discourage investment in property, housing quality may decline over time, financial hardships for property owners, tenant turnover can reduce property taxes, which can reduce amount of government revenue. And security deposit regulations. What is a security deposit? It is money that is collected by a property manager or their affiliate at the start of a rent lease to cover potential damages or other costs related to the property. Measures to address security deposits include regulations on maximum deposit amounts, what deposits can be used for, and how deposits are returned. And as Leona mentioned earlier, AB 12, that's the assembly bill that was approved, that went into effect on July 1st, 2024. And so it limits the security deposits to 1 month of rent for both furnished and unfurnished units. And it does give those leeways for the smaller property owners. What does the city do now? The city does not currently have an ordinance in relation to security deposits, but the city could continue to do nothing other than follow the state law without an ordinance. Current city legal services can provide landlord and tenant mediation services along with fair housing information and assistance, or the city could create an ordinance that follows state law or strengthens the current state law. The pros would include it ensures adherence to the Assembly Bill 12. It has exceptions for owners with less than 2 rental properties, lowers upfront cost, allows greater access to housing, and then some of the cons it could reduce the property owner's protections, potential rent increases to offset lower upfront cost, small property owner concerns, and then potential for property abuse. And then one of our last stations back there will be right to purchase. So what is right to purchase? Right to purchase is when the landlord is required to give the tenant the option to purchase the property they are renting within a specified time period. What does the city do now? The city does not currently have an ordinance in relation to the right to purchase, and there currently aren't any state laws related to this either. What could the city do? The city could do nothing, or the city could look into different options for right to purchase opportunities. Pros, this could be a more affordable for existing tenants to purchase the home that they've been renting. Financial security with home ownership and breaking down class barriers. Asset for tenants to build equity, so it might give the opportunity to someone who could not afford a house beforehand, be a first-time home buyer. And benefits to property owners, they don't have to post the listing or try to find anyone to kind of assist with the sell. Cons, few affordable homes available on the market and lack of rental stock. Tenants may face obstacles when trying to exercise their right to purchase. Potential disagreements or litigation. Doesn't guarantee purchase and can be unfavorable if the home prices drops. All right, I'm going to pass this back on to Leona.
Okay, so just a heads up, as we are going to be breaking soon to start engaging with the various stations in the rear of the room, we do want to let you know exactly what's going to transpire at the close of this presentation, and that today is the event. So all the comments and information that we receive at each station will be transcribed electronically and cataloged. The information will be made available to the public in December of this year, and the information will be reviewed for common themes, ideas, requests that will ultimately be presented to Planning Commission and City Council for their decision on how they ultimately would like staff to proceed. So at this point in time, we would like to allow each and every one of you to start engaging actually with our station. We have amazing staff that are here to engage with you, answer any questions that you may have.